Hello, everyone. My name is Alice Witt. I'm a postdoctoral research fellow in the School of Law at the Queensland University of Technology in Brisbane, Australia. And it's a pleasure to be presenting the full paper that I've co-authored with Associate Professor Anna Huggins, Professor Guido Governatori, and Joshua Buckley. So this paper presents what is, to the best of our knowledge, a first of its kind experiment that aims to shed light on how different legally trained people interpret and convert Australian Commonwealth legislation into machine executable code. So first, I'll briefly provide some background information, and then I'll explain why we focused on Australian copyright law. Next, I'll outline our experiment design and methodology, then some results, and I'll finish up with some concluding remarks and, of course, questions. So first, I just wanted to situate this experiment within the burgeoning rules as code movement, a label for diverse initiatives that reevaluate how, when, and for whom government rules are made. So there are two main rules as code approaches to date. The first of which involves converting existing regulation, including statutes, into machine executable code so that computers can read it and then use it to carry out programs. The second approach involves co-drafting regulation in both natural language and machine consumable format at the same time to enable computers to model the effect of the law. So while decades of research inform these overlapping areas and countries including Australia, New Zealand, France, and Canada have made significant inroads with the practical rules as code movement, challenges persist in ensuring that encoded rules are transparent, traceable, appealable, and what we focus on in this experiment, legally accurate. So against this backdrop, last year, we commenced a multidisciplinary and collaborative research project that seeks to identify the legal and the coding challenges of converting Australian statutes into computer code, research that largely falls within the first rules as code approach, given that we're focusing on existing legislation. So the copyright law experiment that I'm walking you through now today falls under the third phase of this broader research project. So please do look out for our forthcoming publications relating to our other encoding exercises. So, as mentioned, the focus of this experiment is on copyright law, a body of intellectual property that confers rights in relation to the reproduction and dissemination of material that expresses ideas or information. So specifically, participants interpreted select provisions of the Copyright Act 1968. Periodically, I'll refer to this as the CA or the Act. And as part of this, we focused on literary, dramatic, musical, or artistic works known as Part 3 works. So we focus on copyright law for several reasons, including our research team having some copyright law expertise, and because this body of law is widely applicable to a range of stakeholders, but often difficult for lay audiences to understand. In practical terms, our research could be of benefit to large technology companies, galleries, libraries, educational institutions, and archives that often deal with copyright issues in bulk. It could also potentially benefit a large range of smaller content creators who routinely rely on existing material. So in research terms, by generating new knowledge, particularly relevant to the first rules as code approach, we can contribute, or we aim to contribute, to the rules as code movement more broadly. So we conducted this experiment over a 2-week period in late 2020. The population for this experiment was the pool of legally trained research assistants attached to the broader research project. So in this preliminary study, we had 3 participants in total, and I'll call these participants P1, P2, and P3 throughout this presentation. So in week 2, or phase 1, the participants independently coded sections 40, 41, 41A, and 42 of the Copyright Act, which are among several fair dealing exceptions to copyright infringement. So these exceptions are those for the purpose of research or study, criticism or review, parody or satire, and reporting the news respectively. So by independent coding, we mean that participants work in remote coding files rather than the project's shared GitHub repository. Additionally, we instructed participants to assume that the elements for determining where their copyright subsists in a work are satisfied. So we asked them to assume copyright subsistence and to encode the select legislative provisions only. So this means they did not encode the relevant case law, and this was largely due to time constraints. In week 2 or phase 2, participants encoded sections 31, 32, and 36 of the Copyright Act. These provisions outline the nature of copyright in original works in which copyright subsists, and infringement by doing acts comprised in the copyright, respectively. So like in week 1, participants encoded the select provisions only, so they didn't encode the case law. Aside from participants encoding different provisions in each phase or each week, which was a choice that we made largely to avoid participants becoming overly familiar with the statutory text, the main difference between the 2 phases is that week 2 had an intervention, a 2-hour compulsory meeting during which participants collaboratively drafted key atoms or legal terms for manual coding, and they did this in a single remote atom or coding file. The agreed atom file was separate from our other established coding conventions, and after this meeting, participants independently coded the select provisions like in week 1. And participants could refer back to, but they couldn't edit those agreed atoms. So the purpose of this intervention was to test our hypothesis that coders collaboratively agreeing on key atoms or legal terms before commencing independent coding work can increase the similarity of their coded output. And our null hypothesis was the opposite. So to convert select provisions of the Copyright Act into machine executable code, participants used the coding language turnip, which coders can run via the online environment turnip box as shown on the top right-hand side of the screen. As I'm sure that many of you might know, turnip is a programming implementation of defeasible deontic logic, which our collaborator, Professor Guido Governatori, will explain in the next presentation. So I'm not going to go into these technical specifics here. But suffice it to say that we adopted this language because it's particularly useful for coders attempting to express complex rule structures, and in particular, it enables coders to model deontic concepts such as obligations, permissions, prohibitions, and exemptions, which are often present in legislation and were present in the Copyright Act. Also, defeasible deontic logic has been applied in several studies that aim to convert different types of Australian regulation into computer code, and some of those are listed on the screen there. I also wanted to flag that earlier this year, Guido and I put together a masterclass that outlines some of these technical specifics in more detail, and that masterclass you can find on YouTube, as you can see there on the screen. So an important part of this experiment and our methodology for converting legislation into machine executable code, more broadly, is measuring the accuracy of encoded rules in terms of coding validation and what we call legal alignment. Now, these processes are distinct, but both critically important in our view in enhancing the accuracy of encoded rules. So coding validation on the one hand focuses on whether encoded rules adhere in a formal sense to the select coding language and relevant coding conventions. In practical terms, this means that the code runs and it produces a definitive outcome. Coding validation is also concerned with the degree of internal consistency between coders to ensure that the various encoded rules work together as a cohesive whole. Our coding validation processes involved automated and manual analyses of encoded rules. For automated analysis, we created a program that uses string manipulation to pass each participant's atoms into string arrays and then compare the participants' encoded rules to find similarities between their approaches. We also manually cleaned some aspects of the participants' coding files to attempt to enhance the comparability of their rules For example, we adjusted some atom names, which used a mixture of periods and camel case in line with our project-specific naming conventions. On the other hand, legal alignment is concerned with enhancing the congruence between the encoded rules and the true meaning of the select regulation, for example, legislation. And this is an undertaking that heavily relies on human judgment. Our legal alignment process is based on what's called the modern approach to statutory interpretation, and it incorporates the turnip coding language. So a good question here is, why do we conceptualize legal alignment in terms of the modern approach? Well, the modern approach is the interpretive approach currently favoured by Australian courts. In the Australian legal system, the challenge of enhancing legal accuracy of encoded rules, as I mentioned earlier, is made more complex by the strict separation of judicial, legislative, and executive powers in the Constitution, under which only the judiciary can authoritatively interpret the meaning of statutes. So the separation of powers, of course, is not unique to Australia, but the Australian courts have adopted a fairly strict approach, and therefore it's best practice for interpreters, including those attempting to do the conversion work like we did, to adopt this approach and apply it from day one. So as you can see on the screen, Project Blue Sky and Australian Broadcasting Authority provides the leading articulation of the modern approach, which is expressed in very clear terms there on the screen. To summarise, this modern approach requires an interpreter to analyse the text, that is the statutory text, the context of the legislation, and the purpose or the policy of the legislation that they're seeking to encode. And most importantly, this approach has taken courts in Australia away from the previous literal or so-called objective or plain meaning approach to interpretation in favour of a more nuanced contextual approach to statutory interpretation. So what we ended up with is a 7-step legal alignment process, as you can see on the screen, that fuses the modern approach to statutory interpretation with turnip. Now, these seven steps, we don't have time to go through all of these in specific detail, but suffice it to say, as you can see on the screen, step 1 starts with the text, step 2 goes to the context of the legislation, step 3, interpreters consider Parliament's purpose in enacting the legislation, step 4 is where interpreters evaluate the interpretive choices, step 5, where you consider canons of construction, including syntactical and statutory, canons of construction, which help coders address ambiguities in the text. Step 6, coders return to the provision and start the manual conversion work. And in step 7, coders undertake acceptance testing of encoded provisions. Now, if you'd like to see this, of course, in more detail, please do take a look at our paper. Now, in general, we argue that the 7-step process provides a very useful guiding framework that is adaptable and overall can enhance the accuracy of encoded rules. Now, before I delve into our results, of course, there are several limitations that we need to keep in mind, but in the interest of time, I'll just say that the foremost limitation, of course, is our limited number of participants, but we will be addressing this with further research that expands upon this experiment. So overall, the results of our automated analysis show a significant increase in the similarity of atoms and shared rules drafted by participants after the week 2 intervention, as illustrated in Table 1. More specifically, in Table 2, you can see that the similarity of atoms increased from an average of 4.7% in Phase 1 to 57% in Phase 2. The similarity of rules drafted by participants also increased, albeit marginally, from 0% in Phase 1 to 1% in Phase 2. Now, these results overall support our hypothesis that participants agreeing on key atoms or legal terms before commencing individual coding work can increase the similarity of their encoding choices. And importantly, as individual participants encoded different statutory provisions in weeks 1 and 2, this cannot simply be attributed to coders' increasing familiarity with the statutory text. So despite these notable increases in the similarity of atoms and rules from week 1 to week 2, the results show that participants continued to make a range of divergent interpretive choices for which there are three main explanations. The first is the relative difficulty of applying the modern approach to statutory interpretation, which, as previously explained, involves deriving the meaning of a text from close examination of the statute, context, and the purpose. As the Honourable Justice Michael Kirby, a former Justice of the Australian High Court, contends, the task of construing statutory language is notorious for generating opposing answers, none of which are indisputably correct unless the courts have reached definitive conclusions about, for instance, what different provisions mean and how they apply in different cases. So given the potential margin for error in interpreting the meaning of statutory language, it's unsurprising that there were still differences in the encoder's interpretive choices. So second, we also observed that participants encoded the select provisions with varying levels of granularity. And by granularity, we mean the extent to which coders split or broke down the statutory text into discrete parts. So take, for example, the atoms on the top right-hand side of the screen that participants created for Section 40 of the Copyright Act that establishes a fair dealing exception to copyright infringement for the purposes of research or study. So here you can see that P1 or participant 1 adopted a high-level approach that combines research and study into one atom, while P3 uses multiple fine-grained atoms that distinguish between research or study. So in general, we advocate for a more fine-grained approach that provides as much detail as possible, as you can see in P3's approach there. But as the results illustrate, participants, despite being from the same team, adopted different levels of granularity. Now, another possible explanation for the differences that we observed is that coders can use the turn-up language in different ways to achieve the same outcomes. So an interesting example comes from week 2 of the experiment, where participants encoded Section 31(1)(c) of the Copyright Act on the bottom right-hand side of the screen. So this provision establishes that copyright in a literary work, a musical or dramatic work, is an exclusive right to enter into commercial arrangements in respect to the works that are created. And the select encoding for the provisions are in Table 3 there on the screen. So of particular note is how P1 encoded the provision in one rule and dealt with the statutory text other than a computer program using the not operator, which I'm circling there on the screen. P2, however, adopted a more complex approach by creating 3 rules, 2 of which establish the exclusive right not apply to a computer program. So while these approaches are both technically sound or valid when using turn-up syntax as the relevant benchmark, the former is arguably more straightforward. And this example highlights that differences can arise even when coders undertake similar training, they use the same language and work in the same team. So after undertaking automated syntactical analysis, we manually cleaned the dataset to attempt to improve the internal consistency of the encoded rules as part of the coding validation process. And we found that these measures improved the baseline average similarity of atoms from 4% to 39% in week 1, and in week 2 from 57% to 84%. And most notably, coding validation measures significantly improved the average similarity of rules from 0% to 16% in week 1, and in week 2 from 1% to 38% in week 2. So these results underline the importance of shared vocabulary, of shared conventions, but also teams having processes in place for managing alternative, technically sound rule structures with a view to reducing interpretive differences down the line. Now, of course, it's important to note that adopting these different coding validation measures can give rise to certain risks of playing with data, including biases and erroneous outcomes. And these risks lead us to explore the importance of interpreters achieving legal alignment between encoded provisions and the statutory text, to which I'll now turn. So as I mentioned above, legal alignment, as distinct from and in addition to coding validation, is vital for ensuring the accuracy and the legitimacy of encoded legislation. And it is a further step in checking the accuracy of individual coding choices that focuses on our interpretation of the provision using a judicially confirmed process as the basis for interpretation. So here we use the modern approach to statutory interpretation. And critically, it is distinct from a claim of legal validity that the encoded rules accurately reflect the law. So we aim for legal alignment as opposed to legal validity. So as noted above, participants encoded the select provisions only, mainly due to time constraints, which means that the legal alignment processes were undertaken by the research team after the experiment. And this subsequent legal alignment process highlighted the complexity of attempting to evaluate the extent to which encoded rules align with the languages and logics of a statute. So to illustrate this point, it's useful to return to the encoding choices for Section 40 of the Copyright Act, for which participant 1 adopted a high-level approach and P3, or participant 3, adopted fine-grain atoms. So this provision, which is one of several exceptions for copyright infringement, establishes that copyright in a work or an adaptation of Part 3 works is not infringed by a fair dealing for the purpose of research or study. And the wording of this provision is significant, in particular, legislature's use of research or study. So this raises the question of whether an interpreter should encode terms conjunctively, as in research and study, or disjunctively, as in research or study. So in the case of Degaris there on the screen, Justice Beaumont stated that terms research and study take their dictionary meanings and most critically should be considered disjunctively. And indeed, the court considered research or study separately. So this suggests that P1's decision to encode the terms in one atom, so as purpose of research or study, risks deviating from the true meaning of statutory text as articulated by the courts. And P3's fine-grain approach to construing the encoding of the statutory language appears to better align with the court's interpretation of the statutory text. And we only gleaned this after undertaking our legal alignment processes based on the modern approach to statutory interpretation.
Ms. Alice, 5 more minutes, please.
Yes. So just wrapping up to ensure that I have enough time for questions. So I wanted to reiterate several key points from our experiment. So the results of our experiment illustrate the complexities of attempting to reproduce the languages and the logics of a statutory text in machine executable format. So while our analyses are preliminary and we have provided a first of its kind experiment that examines how different legally trained people interpret and convert legislation into computer code, what we've done here is illustrate that an intervention like we had in week 2, which was the meeting during which participants collaboratively agreed on key atoms for manual coding, can significantly increase the average similarity of atoms and, to a lesser extent, those rules. So this finding, among others, supports our hypothesis that coders collaboratively agreeing on key atoms before commencing that coding work can be a very useful thing for rules as code teams. And importantly, can enhance overall the technical coding validation, but also the legal alignment of those encoded rules. So despite these similarities though, we noticed that participants made a range of divergent interpretive choices, which we argue are most likely due to the complexity of statutory interpretation, to encoded provisions having varying levels of granularity or fine-grained detail, and third, the functionality of our coding language turnip. And this underlines that interpretive differences can arise even when coders undertake similar training, use the same language, and also work in the same team. So this further underlines the importance of having established processes and conventions when undertaking this work. And lastly, but most importantly, we contend that rules as code initiatives and teams must ensure that they have processes for both technical coding validation and legal alignment, both of which are critically important in enhancing the accuracy of digitized legislation. And we believe that this is important, particularly in light of well-established statutory interpretation norms and broader public law principles, including the separation of powers. And to ensure that this work is done well, we advocate for multidisciplinary expertise across legal subject matters such as copyright law, statutory interpretation, and technical programming practices. So thank you very much. I'll now hand back to Fernanda.
Thank you very much, Ms. Alice Witt. It was a great speech. Well, we have a question from Hugo Lopez. First, he says that it's a really interesting piece and he thanks you. And I would like to hear your comments from annotators on the understanding of the formal language. Did these influence the annotation process? Did you experience that some parts were different to agree upon?
Yes, we did experience that. And I should say that as part of our coding team, everyone was legally trained, but the team had divergent experiences in computer science, so different levels of experience with undertaking this coding work. And so, yes, there were certainly instances where it was difficult to reconcile some interpretive differences. And what we've taken from this is, number one, the importance of undertaking training with experts like Guido, who was involved in these processes. But also after this experiment, we realized that we needed to further iron out or clarify some of our coding conventions and approaches to enhance accuracy going forward. So I hope that that answered the question, and thank you for that question.
Thank you. Well, if you want to say a few more words, then we go to the next one.
That is only to say that I very much appreciate the opportunity. I did fly through some of those details, so if anyone would like any more, please do read our paper. And if you have any feedback, please feel free to email me at any time.
Okay, thank you very much.
Mr. Guido, I have a question for you from Kevin Ashley. Don't you have to deal with syntactic ambiguity in the legislative text a la Lehman Allen? How do you address it?
Very much.
Okay, so
Public law principles, including the separation of powers. And
am I live now?
Mr. Guido, I have a question for you from Kevin Ashley. Don't you have to deal? I think you have to close your browser of the event.
Yes, so in general, yes, we have to deal with syntactic and grammatical ambiguity. However, in this particular experiment, we haven't had instances, and for a simple reason. First of all, the Copyright Act, it's a very well used and very well drafted piece of legislation. So we didn't find instances. Now, if there are some syntactic ambiguities, it means that then there will be different, possibly different interpretations, and then this will be reflected possibly by the interpreter, and then we will have different encodings by different interpreters. Some of the other questions were one from Mario Bianchi, and it's about the open texture. Yes, it's absolutely possible to model open texture terms. And actually, in our encoding practice in the guidelines, we instructed the interpreters, the encoders, to identify such terms. And then there will be some other ways to do it. So essentially, well, either we use an ask the human whether it's true or false, or a third party can create additional interpretation and additional rule set to define such interpretation. Finally, there was a comment by Trevor Ben-Capon, and it was about the study or research. And he mentions that, well, when he was encoding in the early 90s, if they were appearing always together, then they were encoded together. And essentially, yes, it's exactly right. Even for us, we would have taken that approach. However, we had court cases where the court explicitly mentions that they should be treated separately. And that's why we prefer to use the court cases. And also, this is related to the question by Kevin about the syntactic ambiguities. In case there are syntactic ambiguities and you are not able to solve it immediately, you have to consult additional documents, precedent, the answer, the note for the drafting, and so on to resolve the ambiguities. And if it's not really possible, then you will have multiple interpretations.